Nature of Constitution. On the significance of the Constitution, Dr. B.R. Ambedkar said, Constitution is not a mere lawyer's document, it is a vehicle of life, and its spirit is always the spirit of age. On the nature of Constitution, Dr. B.R. Ambedkar said, so long as you do not achieve social justice, whatever freedom is provided by the law to you will be of no avail. On constitutional morality and constitutionalism, Dr. B.R. Ambedkar said, however good a constitution may be, if those who are implementing it are not good, it will prove to be bad. However bad a constitution may be, if those implementing it are good, it will prove to be good. Now, come to the Constitution. The Constitution serves as the foundational law on which other laws are constructed and enforced. Constitution is a set of fundamental legal political rules that bind all state actors and institutions, including legislature, executive, and judiciary, ensuring supremacy over ordinary law. The Constitution defines the framework of government. The Constitution delineates the distribution of power, for example, 7th Schedule. The Constitution also sets forth the foundational principles and objectives that govern the uh, state, for example, Preamble and DPSP. The Constitution derives legitimacy from public acceptance, reflecting broad consensus and societal trust. Uh, Constitution possesses rigidity by requiring special procedure for amendment. It conforms to democratic standards, at minimum ensuring representation, accountability and protection of fundamental human rights as recognized in international law. Indian Constitution is often criticized as bag of borrowing. Uh, so arguments in favor: fundamental rights borrowed from United States Constitution. Directive principle of state policy inspired from Irish. Parliamentary system mirrors the British model. Federal structure, Canadian Constitution. Emergency provision, Weimar Constitution of Germany. Fundamental duties, Soviet Constitution. Concurrent list, Australian Constitution. Judicial review, American system. Arguments against: nobody holds any patent right in fundamental ideas of the Constitution, said by Dr. B.R. Ambedkar. First, the crafting and implementation of its provision were guided and adapted by Indians to accommodate the diverse local realities, for example, federalism. Second, Indian civilizational values can be, for example, equality, fraternity, liberty, federalism, republic, democracy can be traced back to ancient Indian history. For example, secularism in the Indian constitution is influenced by Sarvadharma Sambhav. Equality principles under Article 14 to 18 inspired from Rig Veda. Unity of all human beings. Mm, Arthashastra calls individual liberty and property rights as essential components of good governance. Similarly, Mahasangha, or the Sabha and Samati, were the ancient assemblies showing republic and democratic practices. Third point against bag of borrowing is unique synthesis, not blind copy. For example, fundamental rights inspired by US Bills of Rights but subject to reasonable restriction, reflecting Indian socio-economic realities. Certain basic features are common in all democratic constitutions in the world, for example, protection of individual rights, separation of power, rule of law. Last point against: many provisions were of Indian origin, for example, Finance Commission, reservation, etc. Now, next question: Constitution as a living document. According to Woodrow Wilson, living political constitutions must be Darwinian in structure and in practice. First, balance between rigidity and flexibility under Article 368. Second, judicial interpretation, right to privacy recognized as part of Article 21. Third, expansion of fundamental rights, example, right to education made a fundamental right under Article 21A. Environmental protection interpreted within right to life. Fourth is responsive to democratic aspirations, for example, reservation for women in parliament and state assemblies, 106th Amendment Act. Fifth is balance of continuity and change. While adapting to modern issues, it maintains core values of sovereignty, democracy, secularism, and equality. The last point for living constitution is inclusivity. According to President Draupadi Murmu, the makers created a comprehensive constitution due to their sensitivity towards each section of the society and awareness of each level of democracy. Now, limitations and challenges of the living constitution. The first is overuse of amendments, excessive amendment, for example, 100 plus amendments. Reservation policy change, 77th, 81st, 85th, 103rd. Second point, limitation, is judicial overreach concern, example, NJAC case. Third is ambiguity in basic structure doctrine. The doctrine is vague and judges decide its scope case by case, leading to uncertainty. Fourth is tension between flexibility and stability. Example, emergency provisions show how flexibility can weaken rights. Fifth, socioeconomic gaps in realization. Example, directive principle like right to work or nutrition remains partially realized despite Manrega and NFSA. Sixth, political motives. For example, 42nd Amendment, right to concentrate power in the center. Seventh, complexity for common citizen. The Constitution's vast length and legal language make it less accessible to the ordinary people, challenging its participatory legitimacy. Next topic is constitutionalism. Constitutionalism is a political philosophy centered on limiting government's power through a constitution, ensuring government operates within the bounds of law and protecting fundamental rights. In Ayar Coelho case, Supreme Court held that constitutionalism is a legal principle that requires control over the exercise of governmental power to ensure that it does not destroy the democratic principles upon which it is based. Similarly, in the Rameshwar Prasad case, the Supreme Court of India held that the constitutionalism or constitutional system of government abhors absolutism. It is premised on rule of law, in which in Rameswar Prasad case, the Supreme Court held that constitutionalism or constitutional system of government abhors absolutism. It is premised on the rule of law, in which subjective satisfaction is substituted by objectivity provided by the provisions of Constitution itself. Louis Henkin defines constitutionalism as constituting the following 9 elements. First, government according to the Constitution. Second, separation of power. Third, sovereignty of the people. Fourth, constitutional review. Example, Raja Rampal case. Judicial review extends to parliamentary proceeding if they violate constitutional principles. And second, IR Coelho case. Laws placed in 9th schedule after 1973 subject to basic structure doctrine in for reinforcing constitutional supremacy. Fifth point is independent judiciary. Sixth is fundamental rights as check on government's power. For example, Shreya Singhal case struck down Section 66A of IT Act for violating freedom of speech under Article 19(1)(a). Seventh point is rule of law. Ensures uniform applicability of laws. For example, Indira Gandhi versus Raj Narayan case, 1975, struck down law exempting PM selection from judicial review. affirming no one is above the law. Eighth point is civilian control of the military, ensuring it remains subordinate to democratic institutions and preventing political interference. Ninth point is no state power or very limited and strictly circumscribed state power to suspend the operation of some part of or entire constitution. For example, restrictions on the use of Article 352. One of the topic is constitutional morality. Constitutional morality is not a natural sentiment, it has to be cultivated, said by Dr. B.R. Ambedkar. British classicist George Groth described it as a paramount reverence for the forms of the constitution of the land. Constitutional morality refers to overarching set of principles that guides the interpretation of constitution, particularly when addressing complex legal questions. It is derived from the spirit and fundamental values enshrined in the Constitution, such as justice, liberty, human dignity, equality, fraternity, etc. However, its scope is not confined to these explicitly stated values, but extends beyond the literal text of Constitution as well. Recent news: while introducing Constitution 130 Constitutional Amendment Bill, which proposes automatic removal of Prime Minister, Chief Minister, and ministers uh, if they are detained or arrested for 30 consecutive days on charge punishable by 5 years or more imprisonment. Home Minister held that it was aimed at upholding constitutional morality and public trust. However, bill was criticized as abusive constitutionalism. Uh, Abusive constitutionalism means use of formal constitutional change to make a system significantly less democratic, entrench power, disable checks, and reduce electoral competition. So it erodes democracy by first. So what I am saying now is basically the negative points of 130th Amendment Bill. First is presumption of innocence. Removal on mere detention, not conviction, undermines rule of law and invites politicized targeting. Second is unequal standards, creates asymmetry. MP MLAs removed only on conviction but ministers on detention. Parliamentary confidence eroded, displaces legislative majority principle under Articles 75 and 164 with police or judicial discretion. Next point is executive authority undermined. Uh, that is, scripts strips PM/CM's prerogative to select or dismiss ministers, politicizing accountability. Next point is governance destabilized. That is, cycles of resignation and reinstatement weaken stability and fracture coalition. Next point is opportunism encouraged. Enables ruling parties to weaponize detention to eliminate rival. Last point is incoherence in standards. A convicted legislature may remain while a detained minister may resign, violating fairness. And the last point is authoritarian tilt. It empowers law enforcement over parliament, reflecting abusive constitutionalism. Anyway, so we were talking about constitutional morality. So, pillars of constitutional morality. George Groth, in his book History of Greece, described constitutional morality as a rare and difficult sentiment. First point is paramount reverence for forms and procedures of the Constitution. Second point is adherence to law while enabling open criticism of authority. Third point is need for public reason, self restraint, and trust in institutions. Other pillars: rule of law, institutional integrity, uh, for example, independent functioning of constitutional bodies, Third is democratic spirit, for example, respect for dissent and procedures. Fourth is a progressive interpretation to reflect its principles in changing context, for example, privacy. Next, fifth is equality and dignity, example, Sabarimala judgment. Sixth is constitutional values, that is liberty, equality, fraternity, secularism, dignity, etc. Seventh is democratic principles, that is participation, representation, and accountability, for example, social audits. Eighth is fundamental rights, protecting freedoms and personal liberty from arbitrary state action. SOP and checks and balances. Ninth one was SOP and checks and balances to prevent concentration of power. For example, NJAC verdict. Uh, Judicial elaboration on constitutional morality. Keshwananda Bharati case upheld basic structure as a reflection of constitutional morality above political majority. Second is Naz Foundation and Navtej Singh Johar case 2018. Supreme Court decriminalized homosexuality, stating constitutional morality must prevail over social morality or majoritarian opinion. Next is Sabrimala case, affirmed women's entry in temples on grounds of constitutional morality in gender equality. Fifth is Government of NCT of Delhi versus Union of India. Supreme Court held that constitutional morality ensures cooperative federalism and prevents concentration of power in the hands of one authority. Mm, Good criticism of constitutional morality, judicial overreach. Courts often expand the idea beyond text, raising concern about unelected judges imposing their own values. Second is vagueness and subjectivity. No fixed definition. Interpretation depends on judicial philosophy, leading to inconsistency. Third is conflict with social morality. That is, excessive reliance may alienate traditional or religious communities, creating friction. For example, opposition to Sabrimala case. Fourth is undermines popular will, that is, risks privileging constitutional ideals over democratic majority opinions, fueling debates on counter majoritarianism. Fifth is implementation gap, that is, despite being invoked, societal practices often remain unchanged. Sixth point is risk of instrumentalization. Without safeguard, it can be weaponized to justify authoritarian measures. For example, weaponization of detention laws like UAPA, PMLA, etc. Seventh is dependence on judiciary. Over-reliance on courts for enforcing constitutional morality weakens the responsibility of legislature and executive. And the last point in criticism of constitutional morality is some critics argue that the concept of constitutional morality remains understudied and there is a need for a consensus to be reached for defining and applying this concept. Next way forward is inculcating constitutional morality. The first point is civic education, that is, introduce constitutional values, liberty, equality, fraternity in schools and universities through civic studies and debates. Second is political accountability, ensure elected representatives uphold constitutional ethics via stricter codes of conduct and parliamentary oversight. Third is institutional integrity, strengthen Election Commission of India, CAG, Lokpal, judiciary to function impartially, ensuring fidelity to constitutional principles. Fourth point is cultural integration, that is, align social morality with constitutional morality through campaigns, that is, bottom up approach rather than top down approach. Fifth is capacity building, that is, train civil servant, police, and judges in constitutional ethics to prevent misuse of authority. And the last point here is periodic reviews of law, update outdated laws, for example, sedition, marital rape, to ensure consistency with constitutional ideas. Jürgen Habermas advocated constitutional patriotism, that is, citizens must build loyalty to constitutional values and processes, not ethnic or religious identity. Similarly, Amartya Sen and Nussbaum, Martha Nussbaum, emphasized the role of public reasoning and deliberation as essential for democratic culture. Constitutional morality can be nurtured through open dialogue and participatory governance. As Rajiv Bhargava notes, it embodies a form of constitutional patriotism that enables unity in diversity while upholding pluralism, making it indispensable for India's democratic resilience. Now, coming to the Supreme Court judgments on various aspects. First, Supreme Court judgment on environment. First is M.K. Ranjit Singh versus Union of India 2024. It recognizes a new fundamental right to be free from the adverse effects of climate change. Second, in Tamil Nadu Godavarman case, T.N. Godavarman case, uh, clarified 2023 clarified that mining is prohibited within eco-sensitive zones and 1 kilometer around national park and sanctuaries. Third is Vanasakti versus Union of India 2026 reversed the verdict on ban on retrospective environmental clearances for projects. Fourth is MC Mehta versus Union of India 1987 established absolute liability for enterprises engaged in hazardous activities causing public harm or leaks. And fifth is Subhas Kumar versus State of Bihar 1991. It confirmed that the right to pollution-free water and air is a fundamental right under Article 21. Sixth is Vellore Citizen versus Union of India 1996. Integrated integrated polluters pay and precautionary principle into the core of Indian environmental law. Seventh is MC Mehta versus Kamal Nath 1997. It applied the public trust doctrine, holding that natural resources belonging to the public, not private players. Eighth is Al Mitra Patel versus Union of India 2000. It directed all Indian cities to implement scientific schemes for mandatory municipal and social waste management. Next, Supreme Court judgment on gender justice. First is Visakha versus State of Rajasthan, 1997. It laid down Visakha guidelines on sexual harassment at workplace, invoking CEDAW. Second, Indian Young Lawyers Association. It allowed women's entry into Sabrimala temple, affirming religious freedom plus gender equality. Third is Ministry Ministry of Defense versus Babita Punia case 2020 granted permanent commission to women officers in the army, ensuring equal career opportunities. Fourth is Sayara Bano versus Union of India 2017 case that declared instant triple talaq unconstitutional, strengthening Muslim women's rights. Fifth is State of Jharkhand versus Shailendra Kumar Rai 2022 case that declared the archaic practice of conducting the two-finger test on victims of rape as unconstitutional and illegal. Sixth is Joseph Sain versus Union of India 2018 that decriminalized adultery, ruling that laws treating women as property of husband are unconstitutional. Seventh is Vinita Sarma versus Rakesh Sarma case 2020 granted daughters equal co-parcenary, that is inheritance right in ancestral property regardless of when the father died. Eighth is Dr. Jaya Thakur versus Union of India 2026 It recognized access to menstrual hygiene facilities and sanitary products as fundamental rights. Article 21 in schools. Ninth is Jane Kaushik versus Union of India, 2025. It mandates equal opportunity policies for transgender persons in both public and private sector workplaces. Last is in sexual offences sensitivity guidelines, formed expert committees to eliminate gender insensitivities, reason, reasoning, and patriarchal stereotypes from judicial orders and rulings. One negative example is Shivangi Bansal versus Sahib Bansal, 2022 case. Supreme Court directed implementation of Allahabad High Court guidelines mandating a 2-month cooling off period in matrimonial cruelty cases, restraining police from arrest or action during this time. Next is Supreme Court judgments on children. The first is Bandhwa Mukti Morcha versus Union of India case 1984. It declared bonded child labor unconstitutional and expanded Article 24 and 21 protections. Second is MC Mehta versus State of Tamil Nadu 1996 case. It banned child labor in hazardous industries, mandated rehabilitation and education. Third is Unni Krishnan J.P. versus State of Andhra Pradesh 1993. It recognized right to education as part of Article 21. Fourth is Independent Thought versus Union of India 2017. It declared sex with minor wife, that is below 18 years of age, as rape, overriding marital exception. Fifth is Society for Unaided Private Schools versus Union of India case 2012. It upheld that the 25% reservation for disadvantaged children in private schools under the Right to Education Act. Sixth is Sampurna Behura versus Union of India 2018, mandated the setting up of child protection units and commissions in every state for better oversight. Next is Supreme Court case judgments on tribals. The first one is Kailas versus State of Maharashtra 2011. It affirmed that scheduled tribes are original inhabitants of India and must be protected from historical injustice. Second is Samata versus State of Andhra Pradesh 1997. It prohibited transfer of tribal lands to non-tribal private mining companies, affirming fifth schedule protections. Third is Niyamgiri case 2013. It upheld Gram Sabha authority to decide on mining, protecting tribal religious and cultural rights under Article 25. Fourth is Banwasi Seva Ashram versus State of UP 1986. It directed rehabilitation of displaced tribals due to development projects as part of Right to Life Article 21. Fifth is T.N. Godavarman case 1996 to ongoing. It expanded the definition of forest, impacting tribal access and customary use. It stressed sustainable forest management. Next is Supreme Court judgments on minorities. The first one is TMA Pai Foundation versus State of Karnataka 2002 judgment. 11-judge bench ruled that minority status must be determined at the state level, not nationally. Second is P.A. Inamdar versus State of Maharashtra 2005. It clarified that state cannot impose its reservation policy on unaided minority private professional colleges. Third is Aligarh Muslim University versus Naresh Mansukhani 2024 case. It overruled previous law to clarify that incorporation by statute does not uh, automatically strip an institution of minority status. Fourth is St. Stephen's College versus University of Delhi 1992. It allowed minority institutions to reserve up to 50% of seats for their own community members. Fifth is Sisters of Saint Joseph of Cluny versus State of West Bengal 2018. It ruled that minority institutions are exempt from the Right to Education Act's mandate